Also, the documentation is exhaustive. You require 5 years of financial information. So all 5 years,
look back
60 months. So all of your bank statements, income tax returns, life insurance. I've even had cases where the state has come back and they say, we want to see your homeowner's insurance bills. They can dig that deep into things.
Wow, that's really sad.
And also when you have a primary caregiver trying to do this, it's just unmanageable because you have the biggest stress of your loved one that you're dealing with, their health issues, and then you add this where you're dealing with something that can accumulate up to 1,000 pieces of paper when you're all these bank statements and everything. And then the last thing also is that a lot of times the nursing home will apply for Medicaid for someone. They usually do not get a complete picture of what's happened in the last 5 years. And that can also cause problems if a nursing home applies and the person probably shouldn't have applied at that time. So the nursing home wants you to get approved as quickly as possible, and that's fine. They want to get paid, but they're not going to tell you what you can do to protect your assets.
And so that could put some tenuous situation on the patient.
Right. It could put someone in a situation where they end up having to spend down everything they have, whereas they could have saved maybe their house or maybe some of their bank account or savings. And that's what we do is we help people save their homes and save part of their savings in many cases.
Is someone, so I think you've touched on the next question we wanted to ask you about the financial rules. You already talked a little bit about that. But is a person able to gift their house to a family member, and how would something like that work?
There is a couple exceptions for your primary residence. The first is that if you go into a nursing home and your spouse still lives at home, you can transfer the entire ownership interest to the spouse, and the spouse can continue to live there, and the state can't put a lien on the house. So the second one that we deal with is that if you have what's called a caretaker child, so that's a child who has lived with the parent for at least 2 years, and we can get a doctor to say that, due to the health issues this person has had for 2 years, she would have had to have been in a nursing home if the child wasn't living there. We can transfer the house penalty-free to the caretaker child in that case. And again, the nursing home won't tell you that. And I've had cases where that should have happened and it didn't. And then years later, the child finds out that the state's filed a lien on the house.
Right.
Oh, that's
terrible.
Cool.
Yeah.
So what would be for those that are listening, that are in this kind of quandary right now? How soon before in advance do they need to be talking to you?
Sure. The best thing to do is to plan proactively. So that's while you're still healthy and relatively young. If you're in your 60s and 70s and healthy, we can do some things with different types of trusts we call it a 5-year trust to protect usually your house, maybe a few other, a CD or some stock accounts, so that when that time comes, those assets will be protected. That's the best thing to do. But as is the case with preventative medicine, a lot of people don't do that. They wait till it's too late or until there's a crisis.
So the takeaway is call you today and get it down, right?
Right. Yeah. Another thing people can do, and they should start doing this at about the age of 50, is look into buying long-term care insurance.
Right.
Yes.
Only about 10% of Americans at that age and older have long-term care insurance. One of the reasons is because it's very expensive. And the underwriting is very difficult. It's more difficult to get long-term care insurance than it is to get life insurance.
Yes.
You have to get a physical and all that stuff.
Right.
So who are your typical Medicaid planning clients that you actually see are coming in the door these days?
Sure. So our clients who are planning ahead are usually in their 60s or 70s, and they're healthy, and they might they'll own their house and maybe $200,000 or $300,000 in other assets. And the house is always what we look to protect first.
Right.
That's really what people want to protect. There's an emotional attachment to that.
Yes.
And depending on the circumstances, we might use different trusts to protect other assets. So the second group are what we call crisis planning clients. So that's when someone is in a nursing home or is about to move to a nursing home. And again, because most of us don't do preventative things, when we
Right.
should. That's
Yes.
what most of our clients are, the crisis planning cases.
Wow, that's got to be stressful, and you guys too, as well.
Well, we have a routine that we stick to.
Okay.
Uh-huh.
And we have a timeline where this is when we need to file the application.
Mhm.
So, but it's very stressful for the family. We try and assume that stress and tell them to just give
buffer
us
it.
the documents that we
Uh-huh.
need. We will take care of this part, and you focus on being the caregiver
Mhm.
and the advocate, for your family member.
I think the hardest part is when it comes to having a family member that is in need of a nursing home, there's a lot of like stress and worry about where to put, where you're going to
Right.
have them live. And
Right.
so you've already gone through a barrel of stress already.
Mhm.
So then
Right.
the fact that you have to worry about losing your home or the assets just makes it worse, which is all the more need for prior planning.
Right. And when at the time where a decision's made that, my wife or my dad has to go to a nursing home, they've almost always had something going on health-wise for a
Mhm.
few years. It doesn't
Yes.
just happen all of a sudden.
Mhm.
So that stress has been building
Building.
up that way too.
Mhm.
Right.
It almost seems like they make it so hard. So you just kind of go, okay, fine, I give up.
Yeah.
You know what I
Right.
mean? Like it's so you
Yeah.
almost have to find these, somebody who is in your business, Jamie, that knows the loopholes,
Right.
That knows how to find and wiggle your way through there. So you don't end up kind of, getting on the short end of
Right.
the stick.
The path of least resistance is just to spend everything you have on the nursing home.
Mhm.
Yeah, right,
But
right.
there's no law that says you have to do that. There are laws about transferring your assets and making gifts, but there's no law that says if you go into a nursing home, you have to spend every last dollar on the nursing home.
And that's what people have been talking about
Okay,
that for
that's
years,
right.
right?
They
That's like,
have.
oh my
That's
gosh,
right.
that's it. It's going to drain
Exactly.
everything they worked so hard for.
Right.
Yeah.
Yeah.
Right.
we
And
hear that
even with
lot.
a case where someone's already in a nursing home and they haven't planned ahead, we're still able in a lot of cases to save maybe 50 or 60% of what they have.
Amazing.
Yeah.
Jamie.
Yeah.
Oh, that's
Yeah,
wonderful.
That's great. So I think we talked a little bit about this, about how the planning works for different kinds of clients. Is there anything else you want to add to that?
For the Medicaid planning, it's
Yeah.
just it's not too late to plan, even if you're in a nursing home, as long as you have something to protect. So I don't want people to think, well, my wife or my dad is in a nursing home, so it's too late.
Just
If you
give
still have
up.
something to protect, if you
Uh-huh.
still have $30,000-$40,000 even, it's not too late to do something.
Mhm. Okay.
Oh,
Great.
okay. So
Yeah,
30,
that's good to
40,000.
know.
Right.
Mm-hmm.
Right.
Very good
Okay.
to know. So, I think you kind of already touched on this too. When someone is in a nursing home, that doesn't mean it's too late.
No, and even if the person, at that point probably has dementia,
Mhm.
if the person is not competent, hopefully they have a good power of attorney document that lets their agent do these things. If not, sometimes we've had to go to court to do a guardianship.
Mhm.
So that gets back just to planning ahead with a power of attorney, which is a relatively simple
Mhm.
solution to what can be a complex and expensive problem. That is, who makes my decisions if I am incompetent?
So that brings on another question I know that none of us want to think about is, since we don't know when, who, the kind of the crapshoot of who's going to get dementia and who's going to get early onset. We don't know. That's just a lot of factors there in heredity and lifestyle and whatnot. It seems it makes it even more important to get in to see you guys on the estate planning in general,
Right.
not just
Right.
Exactly.
not just
Uh-huh.
this, but the powers of attorney
Right.
too.
Right.
If anything, just think about how hard you work in your life. You worked for every, penny or dollar that you have saved and earned for retirement.
Mhm.
So the fact that some kind of catastrophe, illness, anything like that can cause that all to go away, is people just have to think,
I think that's
that
people's
they're going to threat.
biggest fear, and then sometimes they don't really know how to address that fear. But I think having somebody like Jamie in your corner that is knowledgeable, can really take away that fear, as well as the
Right.
burden of stress.
Right. We like to think of
Yeah.
what we do for someone that they're making an investment
Mhm.
in their future and their family's future by taking care of these things in advance.
Right.
So ideally, when they come for their first appointment, would be the kind of the family members that are involved in their care, or
Right. Usually, where someone is sick, it's usually the case where spouse will call and say, my husband's been diagnosed with dementia, or a child will call, say, my mom's been diagnosed with dementia. And then at that point, then we have to assess the person's, what's called capacity, meaning are they, do they have the mindset, the mental status to be able to make these decisions.
What process do you use to determine if a person with dementia has that judgment and decision-making ability?
Well, basically, it just involves meeting with the person, talking to them, and observing, or really that's really the first layer of it. Speaking with the family members about what's been going on, getting their opinion. But as far as what we're doing with estate planning, which is, you can really think of it as a will, power of attorneys, making decisions on that. The relevant law imposes 4 requirements on someone to have what's called testamentary capacity. So that's again the cognitive ability to be able to make decisions on yourself. So everyone is presumed to be competent unless determined otherwise, and the only way that you can be definitively declared incompetent is by a court. So what we're dealing with then is, or after someone dies and someone says, hey, mom wasn't competent when she signed this will. So then you're going back retroactively and looking at the situation. So that's why it's important then on what might seem like a borderline case, to have contemporaneous evidence that the person was in fact competent. And if I just maybe mention what the 4 points are that they have to meet. So
please.
I'll try and not use legalese here. So the first, and these are all really, this is all cognitive functioning areas. So the first is, does the client know what a will is, or what an estate plan is? That it's something where they're going to just, dispose of their property on their death, or appoint people to make decisions for them if they're unable to. So that's the first thing. The second then is, they say, does the client know the object of his or her bounty? So that means, is the client aware of who his family is? So in most cases, it's a simple issue. It's my wife and my kids. Someone who's not married and doesn't have kids, it can become a little trickier then. It might be a number of nieces and nephews, but he's only close to 1 or 2 of them. So that's the second issue. The third is that, does the client know the nature and extent of his or her assets? So now we're climbing here a little bit, where what we're demanding on the client.
Right.
They don't have to necessarily be able to write down a detailed financial statement, but they have to have an idea. If someone owns a farm, he needs to know that he owns a farm, for example. If someone is worth $1 million, he can't think that he's penniless. So then the fourth element is that the person has to be able to take those 3 things. I know what a will is. I know who my closest family members are. I know the nature of my assets, and has to be able to articulate a plan of distribution. So again, in a lot of cases, that's just simply as, I'm going to leave everything to my wife or to my kids. But then when we get into things beyond that, where maybe one child is favored more, or someone doesn't have kids, then it becomes a more demanding requirement to be met.
Sometimes, do you ever see like maybe a spouse died, maybe unexpectedly or whatever, and then the surviving, maybe it's the wife, but she hasn't been involved in all of the planning and that the husband did, and it's not dementia, but she's just totally clueless as to
and that's common. And when a client dies, we meet with the family, with the designated decision makers, and we'll go through everything thoroughly, so that the people who need to know what's going on know what's going on. And again, as far as long as then the person the widow understands that, then that's fine. And that brings up a good point when you said someone's spouse has just died. A lot of times there can be issues that cause someone to have cognitive impairment, but it's not necessarily dementia or Alzheimer's. So I think the common medical example is a urinary tract infection, which can just knock the heck out of people and make them delirious almost overnight. Pain can do that. Pain can make it difficult to concentrate. It can impair cognitive abilities. Grief can do that if someone's spouse has just died,
Right.
or stressed if someone, elderly person, maybe one of their kids just died, or they've been diagnosed with cancer or something like that. So that's why it's, important to get all the information when someone comes in. They don't seem like they're just not really all there to find out what's going on. If it's one of those things, then we can take care of it. If someone has dementia and I haven't satisfied myself that that person has capacity, then we move on to, the fork in the road. Either I'm going to say, no, I cannot put a will in front of this person and have them sign it, or let's talk to a doctor. So a common example is someone calls and says, my mom's been diagnosed with Alzheimer's disease and wants to change her estate plan. A lot of times, if the diagnosis is early, it's usually not a problem. You can tell very quickly by talking to someone, asking them about their family, about their assets, maybe some current events, that they're oriented to time, place, their family, their assets. We might just get a doctor from the person's physician that says, yes, this person has testamentary capacity or has the ability to make those decisions.
We've talking about dementia, but more than once in the 16 years we've been doing home care, we've ran into spouses and children that are bipolar.
Right.
And that is just seems like a minefield to.
Yeah, that's very difficult also, because it's not a cognitive impairment like dementia. It's something that is causing symptoms of cognitive impairment. So
and it does affect their decision-making
affect their
capabilities,
decision makers.
so, right?
Right. One of the, there's legally they call it an insane delusion, where there's some cases where they'll say, well, this person had an insane delusion that caused them to make this weird estate plan, so it's not valid.
Okay.
Yeah, so that the mental illness can also be an issue. Even physical ailments can. If someone's had a stroke and can't write their name or can't speak,
Yes.
and then again you have to dig really deep and spend a lot of time with the person, asking questions, maybe getting them to nod yes or no.
Are there red flags when there's a child that's, maybe it's a family of 4 or 6, and one child shows up with mom or dad? And
yeah, that happens a lot, where a child will call and say, my mom wants to look at her estate plan, and that's understandable. The kids are taking care of their parents. Usually the primary caregiver that does that. But then again, we have to meet alone with the parent and ascertain his or her wishes.
Yes.
Right.
And it's almost never a problem.
Yeah.
We can tell it's a problem when we say to the child, okay, but we have to meet with your mom alone. What will give away a problem is where the child objects to that. And then at that point we say, we're not going to go forward with this.
There's certain parts of the law that any lawyer, I guess, has to deal with. But when you're in this area of expertise, there's got to be a lot of additional training and background and updates and additional learning that's always going on, because laws are always changing.
Right. And when we're talking about people's capacity to make decisions, it's really just observational. And again, I'm not a doctor, so I can't ultimately make that decision. And that's why we're if I'm not fully satisfied, maybe we'll have the primary physician to go beyond that. We've had people in some cases where we think it's important enough to have a neuropsychological exam done. That's kind of like the gold standard of determining the level of someone's cognitive impairment.
Right.
And then beyond that, even if that says they're okay, the person has to be okay at the time he signs his documents. So, we had a case once a few years ago, where a man called, set the appointment himself, showed up himself. I could tell he didn't, it was kind of a borderline case. We had a neuropsych done. Said, yeah, he has some cognitive impairment, but he can make estate planning decisions.
But you had sound.
But the problem was is then when I asked him who the names of his children before he was going to sign, he couldn't tell me all of them. So we had to stop at that point.
Oh my.
Yeah. And again, when we're talking about the capacity to make these decisions, on one level, you have the capacity to run a Fortune 500 company. That's not what we're talking about.
Right.
We're not even talking about being able to handle your own financial affairs day to day, because a lot of people, the first sign that we see is they can't balance their checkbook.
Mhm.
Right.
Yes.
Because most people that age are just right on the
Very
button, balancing their checkbook.
meticulous,
And
yeah.
then
Mhm.
when that starts to fail, it's usually a first sign that they're losing executive functioning, but they still probably are okay to sign estate planning documents.
Right.
Sure. Now, would you like to talk about like any of your other services kind of we haven't touched on before we?
Sure. Well, you know,
Close out.
estate planning is really the big service in elder law, and estate planning is really two things. It's a process to get you from where you are now
Mhm.
to where you want, you know, your kids to be usually after you pass away.
Uh-huh.
And there are a lot of things that can happen on the way there. Your
Yes.
kids can get divorced or go bankrupt. You can go to a nursing home.
Mhm.
And it's also based on a relationship.
Uh-huh.
You know, those
Right.
two things are very important, more important than the documents. And that's why a lot of times, you know, when an existing client gets sick or has dementia or dies, that we're one of the first people to find out because we work so hard to build and maintain those relationships
Yes.
with our clients. And in fact, we have a lot of clients that we've represented for 3 generations of the same
Really?
family.
Oh,
Yes.
that's
Oh,
wonderful.
Yeah.
gosh.
Uh-huh.
So you know, those relationships are the foundation of everything, especially with estate
Yeah.
planning, because it deals with people's families.
Mhm.
Sometimes some difficult things, difficult decisions to be made if you have a child who's a drug addict or something like that.
Yes.
Mm.
Yes.
And they confide all those things
Uh-huh.
in us. So it's more than just signing documents. You know, what we hate seeing is when someone goes somewhere or maybe they get their documents from online. It's
Yes.
basically they're just
Mhm.
signing something they might not understand and getting a pat on the back and saying good luck moving forward. We don't do that.
Mhm.
And that's not given enough credence when people are selecting legal counsel. Is
Right.
it?
Right.
Before we get run out of time completely, could you share your contact information?
Sure. We're again Krupp and Krupp. We're located in DeKalb,
Mhm.
and our phone number is 815-758-5444. So again, that's 815-758-5444. I'm saying it slowly because the last time someone called and said you said your number too fast.
Oh, thank you for that.
Also,
yeah.
our website is krupplawyer.com. So the last name krupplawyer.com.
And that's KRUPE.
PP.
PP. There we go. KRUPP.
KRUPP.
Correct.
Excellent.
So I appreciate you having me
Yeah,
here again.
thank
It's
you.
always nice to be invited
Thank
back
you very
somewhere as
much.
opposed to being told, no, it's okay.
I know. We appreciate it.
Oh,
and we
great.
especially appreciate you talking about dementia and
Sure.
and
It's something
capacity.
with our clients that we're always dealing with.
And I think
Cool.
knowing, like you said, you and some other attorneys are being advocates in Springfield, that's wonderful.
Right.
to
Yeah,
know
it's
that-
important. And even
changes in
even
the
within our
works.
group, we have a couple attorneys who represent nursing homes so that you know the state will hear it from both sides, the patients and the
Mhm.
nursing homes, why
Right.
why something needs to be done.
Very good.
Thank
Thank
you.
you.